Here's a quick update on that Minnesota Congressional District 4 constitutional litigation involving Representative Betty McCollum, the DFL party, and state election officials. There was a hearing in federal district court on March 15th, as scheduled, and Nathan Hartshorn from the Attorney General's office appeared for Secretary Ritchie and argued Ritchie's motion to dismiss the complaint filed during the last week of the 2012 general election, alleging violations of the First Amendment by the state of Minnesota. Hartshorn told the court the matter had been fully briefed and the complaint should be dismissed, defendant not properly filing the motion. He then insisted that the federal courts cannot tell the DFL to stop using quotas which limit white men to about 35 to 40% of the voters making the DFL endorsement for Representative McCollum because they are a private organization. He also insisted the state had no obligation to release email addresses of registered voters in Congressional District 4 collected by the Secretary of State, saying that a candidate is obligated to go out and work to raise money to pay for this data, which is collected under the Help America Vote Act, HAVA. This despite the statement of an election official that if she can't give out the email addresses of registered voters, as Secretary Ritchie claims she can't, then she's been doing it all wrong for years. The plaintiff in the case, me, Steve Carlson, Independence Party candidate for Congress to run against McCollum, disputes these unconstitutional views. Among the points I made, the Supreme Court has long held that because the right to vote comes from the federal Constitution itself, even a private individual or a political association like the Democratic Party can be sued in federal court for violating it and the First Amendment. I also said, since the states under HAVA collect the telephone numbers, addresses, and email addresses of registered voters, they should be released under the state's Data Practices Act to eligible voters in the district for political use and elections-related use, and the DFL Secretary of State has no right to withhold them and should only charge the minimal cost for burning the CD for the voter or candidate. The case number at the Minnesota Federal District Court is 12CV2780-MJD-TNL. I, as the plaintiff, have moved that this case be held over until the Minnesota Supreme Court completes its investigation and disposition of the matter under the Minnesota election laws and Constitution, as well as the U.S. Constitution. And I have posted a number of videos on YouTube if you want to find out more about this ongoing important political and constitutional litigation.